Get ready for the dictation. Start. In support of his contention, he referred the decision of Muhammad Jahangir versus Srimati Kirti Devi, reported in 2001 for PLJR 488, wherein it has been held by a coordinate bench of this court that where the court below has not arrived at on the issue of partial eviction, the matter is required to be remanded to the court below on this issue. On the other hand, learned counsel appearing for the plaintiff opposite party refuted the above stated submissions, arguing that the plaintiff opposite party proved his case in the court below, and the learned court below, having dealt with the evidences available on the record, rightly held that need of plaintiff opposite party was bona fide and reasonable. He further submitted that learned court below has considered the issue of partial eviction while dealing with the issue numbers 3, 4 and 5, and therefore it is incorrect to say that the learned court below had not considered the issue of partial eviction. He further submitted that decision cited on behalf of the petitioner defendant on the point of partial eviction is not applicable in the facts of the present case, because the plaintiff opposite party specifically pleaded in his plaint that the partial eviction of defendant petitioner could not fulfill his need. Learned counsel appearing for the plaintiff opposite party further submitted that in course of evidence it came to light that a partition took place between the plaintiff and his brothers, and in the aforesaid partition the disputed shop fell in the share of plaintiff, and moreover the relationship of plaintiff opposite party with defendant petitioner as landlord and tenant is not in dispute, and there was only question before the court below as to whether the need of defendant petitioner was bona fide or not, and whether the need of plaintiff opposite party could be fulfilled by partial eviction or not. He further submitted that so far as availability of alternative accommodation is concerned, the defendant petitioner failed to prove this fact that any alternative accommodation was available to the plaintiff opposite party, and therefore the decisions cited on behalf of the defendant petitioner are not applicable in the present case. Learned counsel for the plaintiff opposite party relied upon decisions of Madhuri Devi versus Sri Raghuvans Jha, reported in 2012 3 PLJR 664. Learned counsel for the plaintiff opposite party further submitted that even if it assumed that plaintiff opposite party along with his sons runs 2 medical shops, even then it cannot be said that need of plaintiff opposite party is not bona fide and reasonable, because the plaintiff opposite party has every right to provide accommodation to his unemployed sons and simultaneously to take help of his unemployed sons for running his own business. He further submitted that admittedly in the present case the plaintiff opposite party is in need of disputed shop for his sons so that his sons could start a medical shop in the aforesaid suit premises. He further submitted that so far as question of partial eviction is concerned, the court has to objectively determine the extent of the requirement, and in the present case, having discussed the materials available on the record, the court below specifically held that need of plaintiff opposite party would not satisfy by partial eviction of the defendant petitioner from the suit premises. He relied upon decision of Girdhar Gopal Singh versus Gorakh Shah reported in 2012 3 PLJR 490. Having heard the contentions of both the parties, I have gone through the record. I find that the defendant petitioner has challenged the impugned judgment and decree on 3 counts. Firstly, on the ground that the need of plaintiff opposite party is not bona fide or reasonable. Secondly, the court below failed to take note of availability of alternative accommodation, and thirdly, the failure of court below to give finding in respect of partial eviction. The defendant petitioner has not denied his relationship as landlord and tenant with plaintiff opposite party in his written statement, and while he got examined himself as DW6, he admitted at paragraphs number 2 and 3 of his deposition that he is tenant of the disputed shop and used to pay rent of the aforesaid shop to the plaintiff opposite party, and subsequently at para 4 of his deposition he admitted that when plaintiff opposite party stopped taking rent, he started sending rent of the disputed shop to plaintiff opposite party through money order. Therefore, the aforesaid fact clearly goes to prove the relationship of landlord and tenant between the parties. Stop.